counsel for the respondent attending.
Yes, that's who that is right now.
And we've got Attorney Larson flying, attending that way too.
Believe,
We're going to give Brian Mason a little bit more time. It's our understanding that he plans on attending this meeting, so we'll wait a couple more minutes longer before we start. All right. It's 3:32, and I will call this meeting of the Wausau Ethics Board to order. Will the clerk call the roll, please?
Kearns,
Here.
Mason,
Here.
DeVos,
Here.
Hostler,
Here.
Dexter.
Here. And in case anybody's missed it, we do have apparently new microphones. They have a bar near the bottom to press when you're ready to speak. And hopefully they'll provide better coverage of what we're saying than the preceding microphones. This meeting has two agenda items, which I think, again, are interrelated. The first one is consideration and possible action to reschedule the hearing date regarding the complaint made against Mayor Dinny. This meeting is basically called to discuss recent developments. At the last board meeting on April 10th, the board voted to invite City Attorney Ann Jacobson and City Clerk Caitlin Bernardi to clarify in writing whether they will testify fully at the hearing on April 30th, 2025, or whether they anticipate objecting or otherwise refraining from testifying regarding the matter of the complaint we are considering, or any aspect of the matter, and if so, the reason why they would do so. They were also invited to supplement the responses they previously provided to the Ethics Board by identifying the categories of information that were being withheld with a brief description. The city attorney and the city clerk were served subpoenas from the board to appear and give testimony for the hearing that was scheduled for tomorrow, the 30th. Both of the responses indicated that the subjects anticipated not appearing at the hearing on April 30th. Both cited the possible adverse effect that testifying could have on the ongoing investigation being conducted by the Wisconsin Department of Justice relating to the facts and circumstances that led to both an election irregularity complaint and to this Ethics Board complaint that is the subject of our proceedings. Attorney Jacobson also cited her responsibilities to her client, the City of Wausau, under the Attorney's Code of Professional Responsibility, as well as the lawyer-client privilege under the Wisconsin Rules of Evidence. It's my understanding that between April 10th and today, the respondent, Mayor Doug Dinny, scheduled depositions from for the city attorney and the city clerk, with the depositions actually scheduled for yesterday, is my understanding. The city attorney and the city clerk have raised legitimate concerns about testifying. However, I do believe that there are important, relevant questions we could ask that they could answer without risking adverse effects on the DOJ investigation or raising concerns for the city, for City Attorney Jacobson about her duties to her client. City Attorney Jacobson also included two statements in her response that I felt needed our attention at the earliest possible opportunity. First, she stated, quote, "I would inform the board that at least 5 additional witnesses exist with direct and personal knowledge of this matter, both leading up to and following the action taken by the mayor that is the subject of this complaint. They would not be subject to the Supreme Court rules of privilege or confidentiality and could testify about relevant facts from firsthand personal knowledge, which I cannot do," close quote. City Attorney Jacobson did not address whether these 5 additional witnesses would have any objection to responding to our investigation on the grounds that it might have an adverse effect on the Department of Justice's investigation. The other statement she included was, quote, "I am proposing and requesting the board consider an adjournment of 90 to 120 days on behalf of the city and the clerk to allow the board an opportunity to identify and subpoena other witnesses, to allow the organization and its employees in this matter, including pre-hearing depositions, to allow the city council the opportunity to consult with and engage counsel to represent the organization and its employees in this matter, including pre-hearing depositions, and to allow the complainants and the mayor and his counsel to meet with and confer and to the extent possible, agree on a statement of facts which would eliminate much of the need for extensive testimony from multiple witnesses. Now, these are the things that I was hoping we could discuss today, and I invite board members to speak up at this time. Give me your thoughts. I assume you've had an opportunity to review the responses from the city attorney and the city clerk. So I'm inviting that discussion at this time. Don't all want to jump up at once and start fighting. I mean, I can start if you like. I've got thoughts on the matter. They're kind of mixed. But maybe if I pipe in here, that'll stimulate some additional conversation. I certainly don't want to see us risk adverse effects on the Department of Justice's investigation. But now it seems like we have reason to investigate further with the suggestion by the city attorney that we have at least 5 additional witnesses. Certainly we should be thorough. If there are multiple people with firsthand information about the facts in this case, we should see if we can get at those facts. I have some concern that the respondent, having depositions that were scheduled for yesterday, may have had insufficient time after those depositions to prepare for a hearing tomorrow. At its April 3rd meeting, the board was required by the ordinance to set a hearing date within 30 days, there being no agreement between the board and the respondent for holding the hearing at a later date. I'm also concerned about the clerk, who is not an attorney, having to testify and be cross-examined by respondent's counsel without representation when there is a risk of adverse effects on the Department of Justice's investigation. Realistically, we don't know whether we will encounter the same resistance from additional witnesses that we have seen from the city clerk and the city attorney thus far, the objection to testifying because it may have an adverse effect on the Department of Justice. Nevertheless, there may well be valuable information they could provide that would assist the board. I guess we don't know if we don't ask. City Attorney Jacobson also raised the possibility that an agreed statement of facts could be developed. That could significantly reduce the testimony that would be needed at a hearing. It could also reduce concerns about testimony that might risk an adverse effect on the Department of Justice's investigation. Such an agreement could be very beneficial to the proceedings. Adjourning the hearing can provide time for the parties and the board to explore the possibility of such an agreement. Adjourning the hearing to a later date to conduct additional investigation to seek information from additional witnesses seems appropriate, but certainly there are arguments on both sides. And I'd like to hear thoughts, concerns that you have. I know I have expressed in the past concerns about delaying this unnecessarily. On the other hand, it does seem like there could be some real benefit to continuing the investigation and adjourning the hearing that's scheduled for tomorrow to a future date. Okay. Attorney Larson?
So I want to focus on what our first agenda item is, which is consideration and possible action to reschedule the hearing. I think, Mr. Chairman, you described some very good reasons for why that might be appropriate, to allow for further investigation, to allow the parties to engage in whatever discovery they believe to be appropriate, and if that discovery results in motions being generated, regarding the process of the discovery. It allows a chance for the board to consider those motions. And one of our goals of our process is to ensure that it's fair and it provides due process. And I think even in the city attorney's letter, she raised some concerns about whether holding the hearing tomorrow would jeopardize the due process issue. So I recommend that the hearing that's scheduled for tomorrow be put off. 90 to 120 days was suggested. Another reason for doing so is we don't really know yet what is going to happen with the membership of this board, and we don't know what's going to happen in that time period with the state's investigation, if anything. We can't assume that if we put it off 120 days, something will happen in the state's process, but it might. And what we know for sure is that it hasn't reached a conclusion as of today. So my recommendation, one other comment, the respondent has already, at our last meeting, requested a delay of this hearing. And so I think it's in everybody's interest and in the interest of ensuring our process is fair, and we're providing due process to put this off, and I'd propose 120 days.
Thank you, Attorney Larson. Any comments from other members of the board?
I'd be interested in well, there's actually another thing that Ann Jacobson asked, and that's to quash the third-party subpoena that she was given. I don't know if you remember that.
That's not on our agenda
That's not on
tonight.
the agenda, okay. So we would not do it at this meeting. Thank you. Second thing would be the goal of getting agreement on the statements of fact.
Yeah.
That sounded actually appealing to me. That would eliminate a whole lot of things. If we can agree on statements of fact, then we could go on. And that would, what? Oh, I'm getting away. Thank you, Jesse. So I mean, anything would simplify or, this process would help me, and I think help in general, if we had that. So is that a goal we could seek at this meeting?
It would, extending the period of time or adjourning the hearing for 120 days would provide time for that to be done. And then the attorneys can start talking to each other about whether there's any agreement that can be made about a statement of facts. And that will then make everybody's work more efficient, I think.
Yeah. No, I would prefer
It
that.
depends on agreement between the parties.
I would just mimic, I think there are a lot of legitimate concerns raised, and I do agree that due process is more important at this point to make sure everybody has an opportunity to be heard and to do that investigation properly.
Attorney Larson, I was wondering, I want to make sure we use the correct terminology for a motion, because I'm anticipating we may be getting close to that. Would this be postponement? Would this be a continuance of the hearing? Would it be an adjournment of the hearing? What's the proper form for this?
I would use the term in your agenda, which is reschedule.
Reschedule.
Reschedule the hearing.
All right, thank you. Jesse, any comments?
Yeah, I mean, the commentary from Attorney Jacobson about there being other individuals who would have firsthand testimony, I would be interested to have more perspective on what other individuals who were firsthand saw in this, to give us a little more insight as to what the events, how they played out. So I think there's a lot here, and I agree. I think that there's more to look at, and I'm not opposed to having the time it would take to do that.
Thank you. Ryan, any thoughts?
Yeah, I always have a lot of thoughts. as it relates specifically to Attorney Jacobson and the clerk's decision not to participate tomorrow, as far as I'm concerned, these are choices that they're making. There are substantive ways they could participate in this process, I think. I think that they could, I still think they could provide some input into this. I'm, of course, sensitive to the positions that they lay out. I thought long and hard about this. I prepared some things that I'm just going to say, and then, is that okay? Is that all right? So, given the current limitations on witness testimony and access to evidence, and considering the ongoing DOJ investigation, this is just my opinion. I think the board should dismiss the complaint without prejudice. That would allow the matter to be refiled when full cooperation is possible, given this extraordinarily undetermined timeline. I also want to state that my term on this board ends on April 30th. While I understand that legal counsel says that I could remain until a successor is appointed, I believe that continuing under these circumstances, these conditions, would not serve the board well. And I don't think it would serve the public well to continue on after the 30th. And so I will conclude my service at the end of my term, which is tomorrow. I'm prepared to make a motion, which is that given the limited cooperations, the legal constraints, and the significant resources already expended, I believe the reasonable action is clear. I move that the Ethics Board of the City of Wausau dismiss the pending ethics complaint against Mayor Doug Denny without prejudice. This decision is based on the current unavailability of key witnesses and critical evidence due to an ongoing Department of Justice investigation. Dismissing without prejudice allows for the complaint to be revisited when all pertinent information is accessible, ensuring a fair and comprehensive review. The last thing are just some remarks. I think we've reached a point where fairness, transparency, and fiscal responsibility all point to the same conclusion. We cannot ethically continue spending public resources on a hearing we cannot complete right now. Dismissing without prejudice, I think it honors our duty. And furthermore, I think it leaves the door open to full accountability later when the conditions for a fair process are restored. I've said all that I've come here intending to say today, and so I'm going to step away at the end of my term. And I wish the board the absolute best going forward.
Thank you, Brian. A motion to
So,
dismiss.
Mr. Chairman,
Yes, Attorney Larson.
you may have been saying what I was going to say, which is that there was a motion made, so there's an opportunity for a second.
We're having a little trouble. You seem to be fading in and out, Attorney Larson.
Procedurally, we're looking for a second. If there is no second, then it fails for lack of a second.
And is this, I mean, the motion is not on the topic, I'm not sure, is on the agenda for this meeting. Just want to make sure. I mean, I have no problem with proceeding if we have a second, but I want to make sure that we're not, violating open meeting laws by considering something if it's not sufficiently covered in the agenda.
I would argue that it is covered because this is a possible action to reschedule the hearing. As stated, the motion suggests the opportunity to recommence the proceeding once the state has completed its work and the witnesses are able to testify.
Okay,
So it is rescheduling in that sense.
I see. Thank you. Is there a second to Brian Mason's motion to dismiss the complaint? Seeing none, the motion will not be considered. I do want to point out in response to Brian's remarks that there is what amounts to a statute of limitations in the ordinance of 12 months. So there would be an opportunity if, for example, the Department of Justice's investigation concludes before the 12-month, before the one-year anniversary of the conduct that is the subject of the ethics complaint. If I'm remembering that correctly, that's the statute of limitations. So there would be a loss of an opportunity to, let's say the Department of Justice completes their investigation and in October they file charges. Even then, there's no adjudication of guilt. So I think there's a real possibility that if the complaint were dismissed at this time, that would be the end of it. Not saying it couldn't happen, but it seems kind of unlikely to me. And anyway, we're still on the question of whether we're going to have a motion to adjourn the hearing or reschedule the hearing, I should say, for, I'll make that motion if somebody is willing to second it, that we reschedule the hearing in this matter for a date that is near 120 days from now. Is there a second to that motion?
I would second that motion.
Been moved and seconded. Any further discussion? Seeing none, all those in favor of the motion to reschedule for 120 days out signify by raising your hand. All opposed? The vote is 4-1. Then the
Mr.
second.
Chairman.
Excuse me,
I'm sorry.
Attorney Larson.
So the deputy clerk will poll the board for a date that is approximately 120 days. That's correct. We didn't pick a specific date, is my point.
That's
So
right.
The deputy clerk will poll the board and a date will be determined and the parties will be notified accordingly, correct?
Got that works.
Correct.
Thank you, Attorney Larson. Then I think this brings us to our second agenda item, which deals with a consideration and possible action to conduct additional investigation into the complaint raised against Mayor Denny. I guess my own feeling on that is, that's kind of the reason why we've put this hearing off, is so that we can conduct the additional investigation. And it seems to me this has come up rather quickly, and I know how much you all enjoy coming here for meetings, but it seems like it might be a good idea for us to have a certain amount of time to give it some thought and come to a meeting where we can actually talk about what questions we may want to send to what potential additional witnesses. But to get that moving, I guess I would like to make a motion to go ahead and conduct additional investigation into the complaint. Is there a second?
I would second.
Been moved and seconded. Any discussion? Doug?
What kind of thing are you thinking, what kind of thing are you thinking of in terms of additional investigation?
What I've got in mind, having had a little opportunity to give this some thought, is something in the nature of what we did for our first round of investigation, which was sending out investigative orders to potential witnesses, asking them specific questions or to provide specific information. But I think we want to be careful. We don't want to have to be doing this over and over again if we can avoid it. So if we can have some time to think and maybe have some discussion at an additional meeting, we can come up with lists of questions. And we'll need to make sure that we have people that we're going to be sending them to as well. Who is it that we want to send this to?
Is
And
there
I
any
think-
way for us to get that information that Ann alluded to in her email, like as far as the names of the individuals that, I don't,
I know that Attorney Larson is making attempts to get that information, to get specifics on who that might be.
Is that
So
what it's-
hopefully at that meeting, we'll have a definite list at that time.
It seems to me that the people are named in the email exchange. There's facilities people specifically named in first name. I've got them printed here. I won't rifle through my papers. The chief of police is specifically named, who is copied on the correspondence as well. I think that's 3. I'm blanking on the 4th and the 5th, but I believe that's the 5 that Ann are referencing is in that initial exchange the morning after, if you will, whenever the maintenance crew was determining the location. And then if you see one person is seeking advice to say, effectively, what do I do? Like, the mayor's told me it's in his office. What do I do? Can you copy? And then, so that's what it seems to me is they're specifically named in that email exchange.
I agree. I think reviewing all of the information we have so far, if you look at who else appears in documents and statements and things that we do have, you can identify a number of people who pop up in that series of information that we have. And I've come up with kind of the same list that you have, maybe a few more. So,
But I do think asking the city, I'm not there yet. So it's not really better than the other one.
not
Okay.
much, yeah.
All right. I do think asking our city attorney for who to name those people would be essential instead of guessing who they are. You may want to add the ones that you thought
Right.
would be worth it, but she says somewhere that these people have a witness of the process. And it looks like those people saw only part of it. So that's why I'm doubtful. I want to find out what she says.
I think that's fair. My response is not necessarily direct to yours, Doug, but I think somewhat rhetorical, which gets us to the first topic that we talked about, which is that the city attorney refused even to give us a summary of the information we requested. I just want to say, like, in effect, we've asked for basic information before and haven't received it. So I think it's a bit of a slippery slope to continue to hope for information to go back to the same people that are not participating in the process in the ways that we've asked, because in effect, by not participating in the process, it's kind of, to me, what it feels a little bit like is it just feels like our charge, the effort that we're trying to put in to do this is being somewhat hindered.
So,
Yeah. Yeah, and-
Mr. Chairman,
yes. Attorney Larson?
as counsel to the board, I have been sort of a for some of the folks involved in this. Over the weekend, I spoke with the respondent's attorney, who had some questions for me, and I happened to talk with the city attorney and asked exactly the question that you're doing. And I do have a list of names. I'd prefer not to go through that list today. I think the chairman is proposing that we set a time to do that and come up with questions, determine which of these we want to pursue. But I can tell you that I have pursued that.
We missed the very last thing you said. There's something
I think you
interfering
just-
with the.
I have pursued that issue of finding out names of the 5 people that were mentioned in the letter.
Okay,
And I do have those names.
all right, thank you. Yeah, that's something we may want to send orders for investigation out to all of those people. We may want to send them out to some of those people. We may want to send them out to additional people. And that's something I think we can discuss after we've had a little chance to think about this and have that next meeting. Other thoughts? I think we have a motion, don't we, on the floor, that we will continue our investigation. All those in favor signify by raising your hand. Opposed? It's one abstention, okay. Four in favor and one extension. One other thing I wanted to mention, well, two other things. One would be at this next meeting that we will have to discuss further investigation, may also want to be thinking about, and this is something Attorney Larson suggested to me, but it sounds like a good idea. You may want to send investigative orders to the complainants as well and to see what they might be able to add besides what is in the complaint. Another thing I wanted to mention, which may be helpful to people before we meet again, and that is, if you noticed in what City Attorney Jacobson sent to us, there was a reference to a Wisconsin Elections Commission case called Schmidt versus Bernardi, and that's the caption for it is EL 24-108. Now, if you go to the Wisconsin Elections Commission website, it takes a little bit of looking to find where they have the complaints, but you can get to the documents that have been filed in that case so far. And I think it would be helpful to the board members to have an opportunity to review what's in those. There's not a lot there. It began back last fall, and it doesn't seem like anything has happened with it for the last few months. But if you can look at the pleadings, the complaint that was filed against city employees, as well as the response from the city employees. So I think that could be helpful to us. I think that brings us to the end of our agenda for today. Can we try and see if we can set a meeting to discuss investigative orders or whatever kind of investigation we want to conduct? How much time out are we looking at here for people?
Would it be possible to look at least 3 weeks out?
That might work well for me as well. I'm going to be out of town from the 6th to the 13th.
So would we be looking at the week of the 19th then? Obviously, holiday, the following week might get in the way of things.
Oh, Memorial Day
Yeah.
weekend? Yeah, I actually don't have a calendar with me. So someone else can help out with that?
Yeah, I think if we look at the week of May 19th,
Okay.
and availability to meet in this room. I know personally I could meet on Tuesday, May 20th at around the same time we've been meeting, 3:34, if this room would be available.
That would work for me. Doug, Jesse, Brian? Oh, that's right, you won't be here, yeah.
I could make that work.
And I can poll for quorum for dates around that time that work for the council chamber.
If we
Okay.
could push to 4 PM, that would work better for me.
Does that work for your calendar as well, Attorney Larson?
May 20th at 4 o'clock works. I have a
Well, I was going to say,
evening meeting that
I
day,
don't know
but
if that's the exact date. I'd have to check the availability of this room and my calendar as well. So I will pull for quorum, Eric, and I will CC you on that email.
it works for me.
All right. I am expecting to be out of town again on the 22nd of May. But see what you can come up with, and we'll work on it. All right. Anything else to come before the
You know,
board?
just,
Yes.
I was just gonna say, it wouldn't have to be so soon. You know, our is now 120 days away roughly, so.
I think our conversation about the investigation happening within a month might benefit us in the long run if we're looking to eventually have the hearing in 120 days. I know it's forever from now, but it may be better for us to have kind of a good idea of what direction we're headed in before the time drags on. It's just my personal perspective.
And I think that, once we issue orders, there's going to have to be a certain period of time provided for responses to those orders. But,
Well, and I would be, and we can go to the next week as well. I, just due to some personal family emergencies, it may be even easier to go to that next week as well.
yeah. Well, Cody, we'll see what might be available. If you want to give me a call to talk about possibilities, Cody, that might be a good idea, because I'll be out of town a couple of times this month, and we'll see what we come up with.
And I just want to
Mr. Chairman,
Yes, Attorney Larson?
just one more detail we should address. We have 2 outstanding subpoenas for a hearing tomorrow. And we should just clarify that those subpoenas are extended to the hearing that is being rescheduled. So they do not have any obligation to appear tomorrow.
Right. And is this discussion of that fact sufficient, or does the board need to take some action?
Well, there may be some technical change we need to make. I don't know that we need to be that technical. But you and I could talk about that, Mr. Chairman, of whether we want to reissue subpoenas or whether, I'm sure both parties will be aware that the hearing is not happening and that those are extended, and presumably the formality may not be needed.
Right. It's clear, I mean, we have acted to reschedule the hearing, so the board has taken some action. Just a matter of notifying, I guess. All right, thank you. Jesse?
I just wanted to say, kind of on a personal note, I really appreciate the time that Brian has spent with us, and in light of his comment that he'll be leaving the board tomorrow, I thank you for the time you put in and for your civil service.
You'll be
Yes,
missed.
I would second that. Thank you
Yeah,
for your
absolutely.
time, Brian.
Yeah, it's been great. Been wonderful. Robin, 5 years. It's pretty awesome. Doug, 5 years. Calvin, a little less. Jesse, a little less. I wish you all the best. And Cody, aren't you so glad you don't have to get bugged by me with my phone calls anymore? So yeah, it's been a privilege to all of you, to work with all of you.
Thank you, Brian.
All right, all those in favor of adjournment signify by raising your hand. That's
need a motion.
unanimous.
No, a motion.
Pardon me?
I'll motion.
Motion.
Oh, we need a motion to adjourn?
I'll make a motion.
All right,
I move that we adjourn.
I'll
Doug moves.
second it.
All right, it's been moved and seconded. Same vote? Same vote. Thank you. Thanks, Cody.